All right. Thank you.
Thank you, Your Honor. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Hurd's affirmative motion to strike, but I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in the light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579 at 585. In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following: publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfault case, 290 Virginia 81 at 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case, 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be in direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory. Carwell, 196 Virginia at 7. And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard in fact made all 3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18, 2018. And let's take the 3 statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, I spoke up against sexual violence and faced our culture's wrath. That has to change. Per page 6 of the opinion letter, the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton 290, Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Christian Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when when they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations." Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, "This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp." And when Jessica White, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," when the USA Today made clear that they, like everybody else who read the op-ed, understood that, as Ms. Heard clearly intended, it referred to Mr. Depp, which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended, that was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children, and that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely. Absolutely, Your Honor. Her name is on the article.
Okay.
What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defaming Mr. Depp. But if I could go to the second statement, and I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carwile, 196, Virginia, at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex-parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex-parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. Mr. Depp